Um, General disclaimer, you guys know that this is just general information that we're sharing with you, not specific legal advice. And also because laws change, this is, I think we always provide a copy of this presentation to you for internal use only. Please don't provide them to your boards, just because it could be misinterpreted and they didn't sit through this presentation. So they may misinterpret what's the bullet points that we have on here. So today we'll be, Colin and I will be going through the new laws that passed this year, or that passed this year. Some of them are already have taken effect, at least one of them, but most of these take effect in January. And then we should have time for questions, and then we'll go through the other questions in the Google Doc that we received. And then if we get through that, then we'll open it up to other questions that you all might have. Sorry, Jessica, did you have your hand raised?
Just a really quick question on your 60-minute complimentary training. That's annually, correct?
No, that's a one-time thing.
A one-time. Got it.
Yes.
Thank you.
And they're normally, I think our regular fee for them is $600, which is, I think not bad when you have like a brand new board that come in. So we have a lot of clients that periodically schedule those training with us because it's really important. It makes your jobs easier, I think, to have something like that.
Absolutely. Thank you.
You're welcome. So electronic voting is the first one I'll be talking about. I think you guys, I know you are all familiar. I presented very briefly on these new laws at your board seminar, but I also covered the laws that took effect this year. But the electronic voting, you guys, so this is an exciting thing for associations. It's been a long time coming. The legislature, lobbyists have been trying to get this passed because there's already a number of states that allow associations to conduct their elections electronically. So this new law, AB 2159, it allows associations to hold voting via electronic ballots. And we're talking about elections that needed to be done traditionally by secret written ballots. You can now do it electronically, except for those elections regarding special assessments and increases in regular assessments that require a membership vote. But for director elections, elections to approve governing document amendments, and also elections to approve granting of exclusive use of the common area, that can be done electronically. But that option is only available for associations that have specific rules about electronic voting in their election rules. So that's why we're encouraging all associations to update their election rules. We can send you, I think we did through Melanie and Paul, the flyer with the pricing to either prepare new election rules or to update the election rules that our firm have prepared in the last 2 years to include that option. It may take a while for associations to actually implement them because you will need an inspector of elections that is able to comply with all of the requirements for holding electronic voting. So one of the things that's required is that the rules allow for members to opt in or opt out of electronic voting. Like it can't be, the only thing available for owners. So even if you have, an election that's done with electronic ballots, homeowners will get a chance to request paper ballots instead. And they need to know that they have that option. It'll require updating the membership list, or sorry, the voting list that the Inspector of Elections maintains, and it needs to specify whether someone has opted in or opted out of electronic voting or paper voting. And then one of the good things for this is if you do an election by electronic voting, to amend governing documents for those voting electronically, you don't have to send a copy of the proposed amendment, which could be a lot if an association is restating their CC&Rs and bylaws. You know, that could be like 200 or more pages being mailed with the ballot, which could be really expensive. But if someone requests a paper ballot in that type of election, you still do have to send them a copy of that. But that should reduce significantly the cost for those types of elections. So I'm going to go in detail a little bit more of what this law talks about. If you've looked at this bill, it's pretty dense. There's a lot of information in it. But again, the key is not for you to read and absorb and interpret it. Just amend the election rule. Number one, update the election rules, and number two, get an inspector of elections who knows who's been doing it. And there are some, especially that have been providing those services in other states, are now coming to California to do them. So there will be those types of inspector of elections that's required to be familiar with these rules. The most important thing with electronic voting is to protect ballot integrity and secrecy. And this is why electronic voting doesn't mean emailing members a ballot and then having them email it back to the Inspector of Elections, because it doesn't protect identity. So there's going to have to be a system set up where they vote, and their vote will remain anonymous. The Inspector of Elections, so these are the special rules in the code that were added because of this new law. The inspector has to be able to authenticate the member's identity, and then also be able to transmit these ballots to an internet-based voting system. So that's why we're not talking about just emailing ballots back and forth. And then there has to be a method to confirm at least 30 days before the deadline what their voting preference is, and that they can actually receive the messages through their email or wherever, and then vote through that system. So this lists the additional duties for Inspector of Elections doing this. I'm not going to go in detail because some of your associations want to probably try to do electronic voting and then be cheap about it and appoint homeowners to handle it. This is why they can't do it. And even some of the Inspector of Elections companies that you're using, you need to ask if they're able to offer this service, electronic voting service, if that's what the association is wanting to do, because there's all these special things that they need to be able to do. So they basically have to have a program or system set up to do this. There's also the timelines are also important, and this is all going to be in your election rules. So it may require it will require starting the process a lot earlier than you are with a mail ballot. So the electronic voting is not necessarily, it wasn't passed to make this cheaper or quicker, the process quicker. It's really meant for accessibility, because there's some communities where having this option makes a lot of sense, and you will have some communities where this is too complicated for most of the members, and you probably want to stick to paper ballots. And then you'll have some where it makes sense to have the option to offer both, or let people opt in or opt out of them. And you'll get, more turnout, more people returning ballots because it's easier to just, vote electronically. Other deadlines, let's see. So the important thing here is actually it's the next slide. So in addition to adopting new election rules with all of these laws and rules about conducting electronic ballots, one of the things to keep in mind, if you have associations that do allow for floor nominations, that's not going to be allowed in electronic voting because you're not able to have that. But there is also a requirement, if this is something that the association is doing, is you need to include a statement in the annual policy statement about the procedures to opt in or opt out of secret written ballot. So it may just be a statement referring to the election rules, basically. And then the third thing that needs to be done is making sure the voting list reflects how someone has opted to vote, the manner that they want to vote. That's probably something that you would want to work with the inspector of elections on. It would be nice if they're the ones updating that list, or at least helping guide you to do that. So those three things: update the election rules, update or include a statement in the annual policy statement, and then change the voting list to reflect members' voting preference. All right. Quickly, the AB 2460 is a cleanup bill. The year before, AB 1458 was passed, and that amended Civil Code 5115. That's that law that allowed associations to adjourn a meeting and then call a subsequent meeting, and at that meeting for director elections, the quorum will be reduced to 20%, 20% of the members. They just cleaned up. I guess there was some confusion about, what type of meeting it was. So these, instead of saying, a reconvened meeting or subsequent meeting, they changed it to reconvened meeting. And then they also clarified that the association, not just the board, may call for the reconvened meeting if quorum isn't obtained. And if you do have, if the association has governing documents where there's no quorum for director elections, then you don't even care about this. Or if they have, their quorum is, 15% of the members, then you drop it to 15% or whatever the bylaw. So this is just for those associations where the quorum requirement for director elections is higher. And so the goal is to, change the quorum requirements to allow for elections to take place, and not, because some associations have a really hard time meeting the required quorum in their bylaws, which is something, a board or association, if that doesn't make sense for them, they should consider amending their bylaws to remove that quorum requirement. But if they have it, then this law should help. And hopefully associations can at least get 20% of their members to submit a ballot and meet quorum. All right, I think, Colin, you're covering the next few slides.
I am. There was a situation in San Diego where a condominium complex didn't have water, I think, or gas for like 3 months. And they got a state legislator involved, and this is the result. The new bill requires the associations start the process of repairing gas, heat, water, or electrical services within 14 days of the interruption of service. So that's a mandatory requirement. If you don't have reserve funds to cover it, this new law allows you to obtain financing from a financial institution without a vote, and then have an emergency assessment pay for that loan. To obtain that financing, or prior to doing it, it's kind of like the emergency statute. You have to pass a resolution containing written findings regarding the expenses and how the reserves don't cover the necessary costs. And it may be that you have not been reserving for utilities previously, which this new bill now requires associations to add utilities as a major component to their reserve studies. So that in the future, if this happens a few years down the road, maybe there will be reserve funds for it. This bill or law does not apply in a situation where there's a state of disaster or an emergency declared by a municipality or a state government or a federal government. So that is that. Workplace violence, civil harassment, restraining orders. Before we talk about this, did everybody hear that the number 6 has a restraining order against the number 7? And it was because 7, 8, 9.
Oh, Lord.
Actually, it wouldn't even, if I was a judge, I would not grant that restraining order, because there's no evidence that 6 was being harassed by 7. It was 8 and 9 that were in trouble. So this new workplace violence amendment to an existing statute updates the definition of harassment as a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person and serves no legitimate purpose. Note the emphasis on person, not the association. But the statute allows associations to seek harassment restraining orders on behalf of their employees, directors, managers, and vendors from that grumpy homeowner in your development that is targeting that particular person, as long as that is based on a continued and focused course of conduct that intends to annoy or vex that person and doesn't have a legal basis. So a little bit more helpful for associations in that regard. Next slide, Ann, if you don't mind. So they can protect against things like assault, battery, stalking, and credible threats of violence or harassment. The length can be up to 5 years, and the violation is in contempt of court. And the key thing is the contempt of court allows an immediate arrest. I know that a lot of times if you don't have a restraining order and somebody's behaving badly on your development, the police will come and they won't arrest the person because there isn't enough evidence or they don't see what you saw. But if there's a restraining order on file and they violated the restraining order, it's an automatic arrest by the police. So it has some advantages in that respect if there is this course of conduct by a specific individual. Okay, next is updates to the balcony bill. This is the SB 326. It's the main change here is that now the inspector can also be a civil engineer. It did not extend the timeline. I know some people were asking around, did this extend the timeline? And it did not. But it used to be that the inspector had to be an architect or a structural engineer. It is now expanded to a civil engineer. So maybe that brings the price of inspections down. Who knows? Everybody's favorite thing, the Corporate Transparency Act, which is basically, financial crimes prevention. And it currently does apply to associations, and it requires that directors, because they have a substantial influence on the operation of the corporation, are deemed as owners They must disclose personal information about themselves, which is their full name, legal name, date of birth, current business, residence address, and an acceptable form of ID, a driver's license or a passport. It requires the associations to file this disclosure of their beneficial owners with the FinCEN. But we don't, you can assist them, but the directors should be doing this themselves personally, and taking care of it. You also want to avoid privacy issues with you hanging on to passports and things like that. You don't want to get in trouble by hanging on to those things or identifying them. So the best thing would be to direct the owners to do it themselves. The owners, by the owners, I mean directors. So that is my update on the law. Oh yeah, the deadline. It's coming up soon. You have your directors have until the end of the year, and then also within 30 days after a new director is thereafter seated. So be aware of that if you have a replacement director, or if there is an election, it's within 30 days after election. So yeah, okay. So those were my recommendations. And Anne, were you going to?
Just general recommendations. I mean, just to sum up, with these new laws, for SB 326 and Corporate Transparency Act, the deadline's coming up. It's basically the end of the year or January 1st. So I know you have a team that is making sure your associations that need to do SB 326 inspections are doing them. Maybe you are acquiring new accounts. So I make sure I take a look for those newer accounts that you guys get, that the board is aware or has already complied with SB 326 if they need to. And again, that law applies to condominiums with more than 3 attached units, with wood-based elevated elements. So maybe not all. So if there is a question about whether an association needs to even do their SB 326 inspection, contact us, contact their legal counsel, and get an opinion on that. Corporate Transparency Act. I don't know. Are you guys working with a third party, or does Collins have like a team that is helping with CTA compliance?
We're working with a third party.
Okay. All right. Good. Okay. That's the easiest. I've seen some proposal. Yeah. We've been asked if we would assist. We're currently not set up, and it's not really cost effective to have lawyers or even our paralegals to do it. We've seen proposals, and they're pretty reasonable from these companies who do it. They probably have a program set up to do it. So that's good. So you guys, I know Paul was on top of this already from the beginning of the year, so he's aware. So I have no doubt you guys are getting your clients to comply with these election rules. In addition to the electronic voting, last year there was a small amendment in the law that basically says that the election, if associations want boards to be subject to the same requirements as the candidates, then they should have that in the election rules. So if we drafted them, it's already there. But if your election rules were drafted by someone else, make sure that's there. But you should want to have, or association should want that. And there's others, new laws that passed in the last 2 to 3 years. Acclamation is one of them. And so if the association hasn't had updated their election rules, and maybe they don't care about doing electronic voting, there are other laws that pass and would make sense for them to update their election rules. And I think the flyer that we shared, or that you can also share with your clients, just talks in general about some of those new laws that passed in the last few years. consider, with the restraining orders, that's great. It's there as a tool, as hopefully a tool of last resort. But you always want to try and avoid and try to, associations should try to control the behavior of its members. And so one thing that can help is doing, adopting a communications policy about how complaints or how requests for work need to be submitted and the time frame for when they will get a response for non-emergency requests, something like that. A policy that prohibits them emailing the board directly. Things like that is really
Requiring them to go to ADR or IDR before they bring it to the board. I've got this now where neighbors, they're going to be at each other for years, and we're going to have to adopt a policy because they're nitpicking everything about the neighbors thing. Oh, this doesn't comply with the rules, and they're threatening to sue the board if they don't enforce the rules. And so if you have one of these policies in place, you can just say, hey, the rules say go do this first.
Yeah, neighbor to neighbor. Yeah, how members are expected to handle neighbor to neighbor issues, whether it's nuisance, architectural issues, they need to try and work things out first. So having a policy in place, just try to help streamline things and provide
Takes the management out of it.
Yeah. And provide reasonable expectations, because we know members these days, they feel like, they should have their emails answered or calls answered in like less than 24 hours for non-emergency things. So also an anti-harassment policy, that's always also helpful. Sometimes boards think like, oh, that's just harassment between neighbors, we don't need to get involved. But you guys know, if it deals with fair housing, there are certain situations where the association does need to get involved and have a record that they investigated the issues and things like that. So something like that is really helpful too. We could provide proposals if you have associations that could use these. And then updating CC&Rs and bylaws. I know associations have, a lot of expenses with SB 326 and Corporate Transparency Act compliance, repairs and all these things with costs increasing. But sometimes updating your CC&Rs and bylaws it's a big expense, but it can save a lot of money in the future if the association wants to change maintenance responsibilities, shift it to the owners to reduce the association's operating and reserve expenses. Also, we know insurance is an issue. We have a lot of associations where, especially single family homes, PUDs that are detached. Some associations governing documents require that for some reason that the association insure those homes, including the interiors. If you have those situations where it just doesn't even make sense, updating, fully updating, or even just a spot amendment of the CC&Rs and bylaws may make sense. And with all these new laws that we're talking about, there's going to be a lot of provisions in their current documents that are in conflict with the law. Of course, the law takes precedence and would govern, but it creates confusion when members see that the association is doing one thing, but their documents say something else. So consider doing that. We can provide a proposal for spot amendments and also for complete rewrites of that. We have a team that's really fast. I think compared to other firms, we can turn around these projects a lot faster because of the team that we have that's dedicated to doing that type of work. All right, so we have a good amount of time. We have 15 minutes. I have 2 questions from Brad and Michael in these slides. So, but before I do that, any questions specifically related to these new laws that we just talked about before I go into the questions on the Google Doc?
I had a quick question. And you were talking about the suspending the annual meeting until a quorum is met for at least 20 days. please correct me if I'm wrong. Wasn't the old timeline at least 5 days and no more than 30 days?
Oh, yeah. Okay. Yes. So you're talking about this thing where,
Yes.
yes. So this new law says the board may call a subsequent meeting not less than 20 days later, at which time quorum will be reduced. And many bylaws of associations say between 5 to 30 days is when you can, yeah. And so for that, I would err on the side of, complying with the 20 days.
Okay.
But, yeah,
Just,
that's
just,
another
just,
one of those. They didn't clean it up, but they really should have. I would comply with that part, but
Okay.
but use your whatever the lowest quorum that either this 20% or if they have a lower one, then use that.
got it. Not worried about the quorum part. Was more worried about the timeline part. I just wanted to make sure that we should be now focusing on at least 20 days, not the 5-day minimum.
Yeah.
Okay.
Yeah. That's a good question. And yeah, another thing that should have addressed. All right. Any other questions about these new laws? Okay. Okay. So the first question, Brad's, it's yours. It says Civil Code 4710 outlines permitted political signage on private property. And then the question is, does the removal 15 days after the election apply to displays on private property or only common area signage? And so, so the 4710, that talks about what you can control on someone's property. So we're talking about if it's a PUD, their lot. If it's a condominium project, then we're talking about their unit and exclusive use common area where they can post certain signs, but it has to be within this, a certain size, can't have, offensive language and things like that. But those are the only things they can really control, the size and then, offensive language. So as far as requiring them to take it out, I don't think the association can do that. It's their property, First Amendment rights and all of that. And that's what that law really tries to protect. So, that's not something that they can control how long they keep it. It's not like Christmas or like holiday decorations, because some people just, want to have that.
All right. So just to clarify, if they have a size compliant sign and they only have one and it's not offensive, they are permitted to keep it up even though the election has ended. If they want to keep it up for the next 4 years, they're allowed to do so.
Yeah. And is that 15-day rule, is that something that the association has?
Well, actually Michael helped me find a little blurb about signage that's like at intersections and things like that on quote unquote public grounds. That signage does need to be removed after 15 days after the election.
Oh, I think I know what you're talking about. Yeah.
But I know that's like for street corners and things like that. I'm talking about, what's on somebody's individual home.
Yeah. And that's the key thing we're talking about. And usually even if it's someone's individual home, associations can pass rules, right? Like the color of somebody's home, you can have a rule, but then you have this code that limits the kind of rules you can pass, the association can pass, and that's not one of them. So, yeah.
Thank you.
Yeah. The next question is Michael's. It says, if the CC&Rs is silent on estate sales and there's nothing in their rules, can the owner have one? I didn't see anything on Davis Sterling on estate sales. Are there any laws that would prohibit an estate sale? So, I have never seen an association governing documents that have anything like that. I know one time I had to draft some rules about garage sales, and then and require like waiver because they wanted to have like a big community wide garage sale. Anyway, for estate sales, I think it's not addressed. And I don't know if this is like a home that has estate sales regularly, because I see sometimes like certain homes are advertised and there's different companies that host estate sales at a particular home. I don't know if that's that type of situation. Maybe it can be characterized as commercial activity. If that is what, maybe, and it depends on the situation. If that's something that's regularly done, maybe. And I guess I would look at other violations. If there's parking violations, if, depending on the hours, if it's really a nuisance, there may be other rules that can be enforced in that situation. Not so much to prevent it, but to discourage or to just keep them in compliance. But I'm not aware of laws that would prohibit estate sales in general. And it may be overreaching for an association to prohibit it unless there's something else, certain ones or certain types of, activities. If it's a gated community, that they may have more grounds to prohibit, the public coming in that situation. So, yeah. So that's
If it's an actual estate sale from the owner, the biggest concern I would have is if the owner passed away, is who's going to be the new owner, and is the son just going to move in and not change owners, and then you can't enforce anything against the person who is moving in because they're not technically an owner. So estate sale for me, it says we find out who the owner is. Does that owner have any debts, the deceased? Because if the deceased has debts and you don't take care of them, you could lose all the debts if you don't file, get the bankruptcy notices or the estate notices and things like that. So, totally off subject and not what you asked.
That's a good idea. That's a good, like a red flag. Like,
Yeah.
Sometimes I see estate sales, they call it that, but it's not really like somebody deceased. It's like just a term.
Well, then to me, it is a commercial activity because you're not like an estate sale. I understand is a natural part of a residential experience and you wouldn't be able to argue, but if they didn't die and they're having an estate sale, that's a commercial activity. And I would shut it down that's me. But
you may be able to, if the board decides if there's enough facts, it's always one of those, depends on the facts and how strong the board wants to fight it. So if it's a one-time thing, it's probably not worth doing all that. But if it's a big thing or a regular thing happens more than once, or it's happened, or a lot of people are doing it throughout the community, then that's worth taking some kind of action on. Yeah.
Agreed.
Anybody else have questions? I didn't look at the Google. I think Ivy looked at it this morning. I don't know if there were.
I had one.
Yeah.
Okay. So in this scenario, it's condominiums. It's a stacked unit at the bottom. There was a water backup, but the unit owner died, and the kids taking care of this unit never went into the master bedroom. So they didn't realize, I think for a couple months, that the water had backed up. So there's tons of damage. And there's potentially mold. I don't know. I just had one phone call so far about this from the daughter. And because, it sat for months potentially. And so now, of course, they're coming at the association for all the damage, et cetera. But there is something in the CC&Rs, even though there are condominiums, and we do normally play for plumbing when it's a common line backup. The CC&Rs do say that the association shall not be liable for interior water-related damage, including damage caused by plumbing backups to the unit, unless it can be shown the association acted with gross negligence in any maintenance, repair, or project undertaken. So, Yeah, so I'm reading that thinking they're on the hook for this, that the association is not responsible, that this is very clearly delineated. And so since we were here today, I thought I would ask.
You're talking about the Marie Antoinette clause there. That is the gross negligence clause. And I think sometimes it's limited just to the interior damage of like personal effects and things like that. But if it's broader and talks about all of the damage and all of the
It says
repairs,
any, yeah, it uses
then
the word any.
the only other thing that you have to consider are, as I'm hearing Anne's voice in my head right now. I'm about to get aggressive, but the consider is mitigation of a potential lawsuit, even though you're in the right for having that. So do you want to assist in some way? You can take a strong stance maybe because there's not anybody living in this unit, it sounds
Right.
like. And then the other part is what is gross negligence, right? Like, so how many?
Yeah, they maintained and hydrojetted last year, so I think they're fine.
Okay. Yeah, then you're probably okay standing on it. That's why you have that provision in there. The courts have upheld that provision. And then there's also an element here of owner neglect that I would argue if I were on behalf of the association, because they're not checking this unit, right? And that if it didn't cause the damage, it certainly caused increased damages, right? By not doing it. So yeah, I think you're in good shape on that. But and then no loss of use under 477.5B and all that. So
All right. Thank
Yeah.
you.
I agree. Yeah, and I think that was a good point Colin made is anytime there's any claim for damages, the party that's claiming damage has a duty to mitigate the damage. So, if they're not fixing things, you can't just sit there and let the mold grow and and affect other units, and whatever you can to protect the common area, do that. But that's, I think, under the facts that you mentioned, there's a good case for the association to try and get that money back from the owner. I mean, I wouldn't do the unit repairs. I'm just talking about like protecting the common area, making sure no mold that spreads to other units, because that's what we usually see. There's a negligent owner. The association had no fault, but then somebody else, a neighbor complains of mold, and then they're saying the association should have stepped in, and there's some, at least there's a little bit of an argument for that. So that's what you're trying to prevent too, claims from other condo owners that you allowed it to spread to them.
Yeah.
Yeah. Sierra.
I have a very similar one, just like that. It's a condominium. It's just one building though. There's new homeowners, and the homeowner waived her inspection, and she just went in there and there's mold on the window. And she was thinking that it may have affected downstairs too. But she called to ask, if there's anything that the HOA can do. And I was like, did you get your inspection, before you moved in? And she said, no, I waived it. And I said, oh, okay. I have to look into that because I don't know. But same question. Like, I just want to make sure. I mean, obviously, it sounds like it's her responsibility, but.
Well, it would depend on what the CC&R say, and what the cause of it is. Because if it's there because the association's roof leaked,
right,
you can't just say, "Oh, well, too bad you waived your inspection." So you might have to get more information,
Okay.
and then have a review of responsibilities if it's not clear of, and I don't know if it's just the window, if it's spread to the drywall or anything like that.
or if it's behind the wall, yeah.
Yeah, there's going to be, there needs to be an analysis of, primarily what the cause was, and then who, the owners versus HOA's responsibility. Like in Sarah's example, that one had like, a provision in the CC&Rs about HOA is not responsible for any interior, even if it's the association's roof,
Mhm.
basically that caused the leak. Hers had that provision, so I don't know if this one has that.
Look for that. It's near it'll be in the maintenance section.
Mhm. Okay.
Yeah, that one might, if she blows it up, that one you might need to get the board to let you send it to legal, because you want to get ahead of it before it blows up even more. And make sure it's clear what the association is supposed to do, because if they're not supposed to do anything, then they would want to know that. So you don't, because I've seen that too, where association, they inserted themselves. And so at some point, well, you open up the walls, you need to fix it. You need to do it now because you did all that, even though you didn't need to in the first place. So
Mhm.
yeah, so it's good to really understand what you're supposed to, what the association's supposed to do.
Okay. Thank you.
Yeah, good luck. All right, we are out of time. If you guys have any other questions, concerns, requests for proposals, feel free to reach out to us, Ivy or Julie also. And then we'll email Paul about his question regarding escrow disclosure. So have a great day, everybody.